you've been considering relocating with a minor child you share with someone else to a different county, city, state, or country, but you don't know how to quite do it and you need legal help. Hello, my name is Danielle Pinkston. I am the attorney and founder of Pinkston Law Group, and welcome to What You Should Know Wednesday. Today's topic is parental relocation. Parental relocation is governed by 750 ILCS 5/609.2. And what you should know first and foremost is a parent who has been allocated majority of the parenting time, or either parent who has been allocated equal parenting time, may seek to relocate with a child. In Illinois, there are 3 types of relocation. The first one is moving a residence in Cook, DuPage, Kane, Lake, McHenry, or Will County that is more than 25 miles from the child's current residence. The second is moving more than 50 miles from a residence in a county other than the 6 I previously mentioned. The third would be moving outside of Illinois and more than 25 miles from the child's current resident. Keep in mind, if the relocating parent stays within the new radius restriction, which is 25 miles, that parent does not need the court's permission before moving. Again, scenario is you own a home in Cook County. It's downtown, but you are seeking to move the minor child out to Calumet City or further south or further north. If it is within 25 miles, you do not have to get the court's permission to move your residence. A parent's relocation in Illinois constitutes a substantial change in circumstances for the purposes of Section 610.5. And the procedure that you need to follow first and foremost is if you're the parent who wants to relocate, you must do the following steps. The first one is you must give notice of relocation to the other parent under the parenting plan or the allocation judgment. Again, you must give written notice, not oral, not verbal, but again, you must give written notice to the parent who is not relocating and who is the other parent under the parenting plan or allocation judgment. 2 is a copy of the notice required under this section must and shall be filed with the clerk of the circuit court. And then 3, the court may waive or seal some of the information required in the notice provision if there is a history of domestic violence. 4, the notice must provide at least 60 days written notice before the relocation is to occur unless such notice is impracticable or unless otherwise ordered by the court. And 5, at minimum, the notice must set forth the following information. First, the notice must state the intended date of the parent's relocation. And 2, the address of the parent's intended new residence, if it is known. 3, the length of time the relocation will last, if it's not going to be an indefinite amount of time or if it's not intended to be permanent. Okay? Please take note that the court will consider a parent's failure to give the other parent notice as a move without good cause. Again, you want the court to believe and know that your intent or intentions to relocate is for a good cause. But if you fail to give the other party notice, the court will look at that in an unfavorable light, and that could adversely affect you. Okay? So, the non-relocating parent, if that person agrees after receiving notice, that person can simply sign the notice and then file that with the court. And again, relocation shall be allowed without any further court action. But 2, keep in mind, the court shall modify the parenting plan or allocation judgment to accommodate a parent's relocation as agreed by the parties, but there's a catch, as long as the agreed modification is in the child's best interest. So, the general rule is if the non-relocating parent agrees after receiving notice, then that parent should sign the notice and file that with the court, and the relocating parent should be able to leave the county, the city, the state, the country without further notice or further consideration. However, there's a caveat, there is a catch. The judge who's presiding over this case must still find that the relocating parent the relocation is in the child's best interest. If the court believes that, again, it's not in the child's best interest to leave, even though the parents have signed, there may be problems. That relocating parent may then have to file a petition with the court and to give the court better understanding and more allegations as to why relocation is in the child's best interest. So notice is required. If notice is given and filed, the court still has the final say in the relocating parent's move. Okay? So you might say, well, what if the non-relocating parent does not agree? They are not in favor. They object after receiving notice from the relocating parent. Well, if that parent objects, and they have a right to object, the parent seeking relocation must file a petition seeking the court's permission to relocate. And again, if you are that parent who files a petition, make sure you go back to the statute 750 ILCS 5-/609.2 to make sure you have all that you need to have in your petition, and that you make sure you write down and tell the court exactly what the purpose of you wanting to leave or relocate and why it's in the child's best interest. That is the heart of everything regarding our parentage statute, and also our the 750 ILCS statute in Illinois. Is it in the child's best interest? That is first and foremost. So once again, you have asked the parent to sign a notice. The parent does not agree. The parent objects. You file your petition. What are some things that you need to have in there? Well, if you must file a petition with the court, it shall consider the following factors. The first factor is the circumstances and reasons for the intended relocation. Again, why are you trying to move the county, the city, the state, the country? Is it because you have a better job opportunity? Will you make more money? Will the child be able to live in a safer environment? Again, what is your reason, or what are your reasons for wanting to leave? That's number one. Number two, the reasons, if any, why a parent is objecting to the intended relocation. Okay, so you're the objecting parent. You have not signed the waiver, and even after the other person has filed the petition, you still object. Why are you objecting? You must also have good faith reasons as to why you are prohibiting, or you are withholding your permission for the relocating parent to leave with the child. Number three, the history and the quality of each parent's relationship with the child, and specifically whether a parent has substantially failed or refused to exercise the parental responsibilities allocated to him or her under the parenting plan or allocation judgment. Again, there's a parenting plan that has been established by the court, or the parents have been given various responsibilities under this parenting plan. And again, parental responsibilities includes two things primarily. That is, one, decision-making regarding the medical, the education, the religion, extracurriculars. And then two, it's parenting time, what used to be called visitation. So you're the objecting parent. Have you been paying child support? Have you been exercising your parenting time with the minor child? Have you been actively involved in the minor child's life? Well, I would hope so if you're objecting, because if not, that could be looked down as unfavorable for you, and it would give your objection very little or minor weight. Number four, the educational opportunities for the minor child at this new location. So you're trying to leave city X. And city Y is a better city, it's safer, it's cleaner, it has a better school system or district. That would be a consideration. Again, the court shall consider these factors that I'm mentioning to you right now. So be sure to do your homework, investigate, see if your new city, town, country, state, whatever, has a better school system, because that would be a factor for the court to consider. Number five, the presence or absence of extended family at the existing location and the proposed new location. Well, let's say we have a mom who is trying to leave the city of Chicago because she has no family here, and the biological father is not being of any assistance as far as parenting time and also making decisions for the child. Well, that would be a strong factor, okay? And especially if this new city, county, state, country, she has family or relatives who would be able to assist her. So keep in mind, do you have family here or do you not have family here? And do you have family or resources or a network to assist you more in this new relocating city, state, country, or county? Number six, the anticipated impact of the relocation on the child. Again, this is all about the child's best interest. And would this child be adversely affected if the relocating parent received an order from the court? Now, for the court to determine this factor, they may and they can appoint a child's representative or a guardian ad litem to interview the child to, figure out if the child is being affected psychologically, emotionally. And again, this would be brought to the court's attention, and the judge would be able to consider this as a factor in granting or denying a petition to relocate. Number 7, whether the court will be able to fashion a reasonable allocation of parental responsibilities between all parents if the relocation occurs. Well, we have a father who is the non-relocating parent, and this father has been actively involved in the child's life since birth. The child and the father have a close bond and relationship. The courts will consider, would this father and this child be able to continue fostering and building this strong bond they worked so hard to maintain in the first place? Okay, so again, if the parent has a reasonable allocation of parental responsibilities and rights, that is considered. And keep in mind, again, that's decision making as well as parenting time. Number 8, the wishes of the child, taking into account the child's maturity and the ability to express reason and independent preference as to relocation. What that means is if the child is 2, 3, 4, 5, 6, 7, the courts may not really consider that child's perspective or point of view because they're easily swayed by another parent trying to entice or get them to agree to or like or say they like the new place they're going to relocate to. But that child could be mature, okay? So the courts would take into account the child's maturity and their ability to express a reason, a well thought out and a well, articulated reason as to why they would like to move. And again, the court would look to the fact, is this child expressing an independent preference or simply repeating what they were told by one of their parents? Number 9, possible arrangements for the exercise of parental responsibilities appropriate to the parent's resources and circumstances and development level of the child. Well, if we have a father trying to relocate to a different city, state, county, or country, but the mother who resides in Illinois is underemployed and cannot afford a plane ticket or, bus or a train ticket, the court would consider that. And the court could require that the relocating parent contribute to the non-relocating parent's airfare and travel expenses. Again, could. It would be very persuasive for you to mention the fact that if the child were to leave the county, city, state, or country, that you would not be able to exercise parenting time because you lack the financial resources or the money in which to exercise your parenting time. Number 10, minimizing of the impairment of the parent-child relationship caused by a parent's relocation. That is pretty much like the other factor I mentioned. Again, the parents have a close bond, and would this move affect that? The court would also consider this as a factor. And the 11th factor is a catch-all. Any other relevant factor bearing on the child's best interest. Keep in mind, the entire 750 Illinois compiled statute is all about the child's best interest when it comes to children, okay? Is it in the child's best interest that the parent who has majority of the allocation rights or the parent who wants to relocate, are they keeping in mind the child's best interest? That is numero uno. That is always going to be first and foremost. Well, that's all the time I have for you today. I hope that today's What You Should Know Wednesday was very informative and clarified some questions that you may have had and you did not know the answer to. Keep in mind, What You Should Know Wednesday is never intended to take the place of a formal one-on-one consultation with me or any other attorney. Also keep in mind, if you still have some questions that are looming in the back of your mind or some questions that you still need to have answered, then I would suggest that you contact me at my office, which is located at 55 East Monroe, Suite 3800 in Chicago, or you can call the office at 773-770-4771. And you can also now book your consultation online at pinklaw.acuityscheduling.com. Again, pinklaw.acuityscheduling.com. Thank you for tuning in, and I will see you next week for What You Should Know Wednesday.